Welcome. Good evening to our friends and colleagues in India, and good morning and good afternoon to everyone else from around the world. As things seem to get better in terms of the pandemic, we are very likely to see an uptick in disputes, and here we are to discuss ADR as a global force for good. The ADR rock stars from the young members group of the Chartered Institute of Arbitrators have together curated this informative and collaborative journey of the ADR World Tour to promote ADR as an effective tool and to provide access to understanding of ADR regimes around the world. A brief introduction about myself. I'm Ishan Madan, a lawyer from Delhi, currently in the US pending admission to the New York Bar. I'm also the founder of Arbitral, a platform advancing research, dialogue, and thought leadership on the interplay between international arbitration and insolvency. Given the growing importance and size of India, the ADR World Tour is here to make its regional stop with a dedicated series spanning 2 days and 4 sessions in India. And we are so very delighted to start with the proceedings today with the session International Arbitration in India 2021 and beyond. And we are so excited to have an audience registering from 33 countries today. Now, before we move to our awesome panelists, I would first like to begin with some housekeeping suggestions. All of the attendees are requested to use the question and answer button at the bottom of bottom ribbon of your screen to share your questions instead of using the chat feature. In the chats though, do drop in a hello mentioning where you are from. Questions which asked by the audience will be taken up towards the end of the discussion. During the event, you may see some poll questions popping up on your Zoom screen. Please feel free to answer those. The answers to the poll questions will be your contribution to a comparative worldwide study that will be published at the end of this tour. Rest assured, your answers will remain anonymous. Must I also point out as a disclaimer that the views shared by the speakers panelists today may not necessarily reflect the views of any organization or entity or firm that they may be associated or affiliated with or that they represent. The views may also only be academic for the purpose of discussion. Anything discussed here shall not be attributable to any related organizations unless the speakers or panelists desire or otherwise indicate so. Now, thank you so much for bearing with the mandatory announcements. Without further ado, let's move to introduce the esteemed people on screen. If you have been following arbitration in India and international arbitration generally, it is inevitable that you know these leaders from the industry. If you Google their names, you'll find a day's worth of reading. So instead of sharing lengthy bios, I invite the speakers to share one thing about themselves that Google does not know. Now let me start with a YMG member from India, Shama Loya. Shama, please tell us something about yourself that Google would not know or show.
That's an extremely interesting question, Ishan. I think something that very few people know about me, and certainly Google doesn't know, and I'm glad that it doesn't, is that I'm a graphologist. I can analyze handwritings and understand or try and understand your personality based on your handwriting. So that's something Google doesn't know yet.
That's quite an asset to have as a lawyer. And next up, Mr. Ratan Singh. Sir, something about yourself that Google does not know.
I don't know whether Google knows this or not, but I must say that apart from being construction arbitrator and construction lawyer, I have done MSc in geology, and I do a lot of mining arbitration as well. I'm the only lawyer in India who has done MSc in geology and does mining matters and mining arbitration.
That's fantastic, sir. Moving on, Dana, welcome to India. We all know you're the president of Arbitral Women and an investment specialist at Omni Bridgeway. But please tell us something about yourself that Google would not know.
Well, it's a pleasure to be here. Good morning from New York, and hello to everyone around the world. I tend to think that Google knows more than I can understand. So I can't be sure. Google doesn't know just about everything about me, but one of the things that I love to do when I'm not doing arbitration and arbitral women and all of the other things that we will talk about today is to go to the Botanical Garden in Brooklyn across in my neighborhood. Most people, when they think of New York City, they think of the Empire State Building and all the monuments and the fanfare of the city. There are some beautiful gems outside of the city that make it a more livable place as well as an exciting place.
Fantastic. And now moving on to my friend and colleague, Shashank Garg, who everyone knows. But Shashank, please, from the horse's mouth, something that Google doesn't know.
So as Dana said, I don't really think that there is anything that Google doesn't know in today's times of compromised privacy. But something that may not be easily available on my bio is that I'm a wildlife enthusiast and I'm very passionate about wildlife conservation as a cause.
Oh, amazing.
Now I think Google would know this too.
Great, fantastic, fantastic. Thank you so much. Welcome all of you. And welcome again to our fantastic audience. So a lot has happened over the last 10 years in terms of arbitration in the country. India has seen a major push towards becoming a hub for international arbitration. We have also seen amendments to the law. Despite the countless opportunities and strides, there are challenges involved, both in terms of legislation and infrastructure. While we can have a web series on the same, we will cover limited grounds today that are enforcement of awards, construction arbitration, rights of third parties, institutional arbitration in India, issues of diversity, and opportunities for younger arbitrators. The flurry of amendments that have taken place in the last 6 years confirms that the concerns of international arbitration community are reaching the ears of Indian policymakers, who are not only taking them into account, but are keeping an open-minded approach in rectifying the past errors when needed. Now allow me to invite our first speaker, Shama Loya. Shama, the trend in judicial pronouncements, both by the Supreme Court and various high courts, have seen India being rebranded as a pro-arbitration jurisdiction. From Bhatia to Balco to Sri Lal Mahal to Vijay Karya to the latest Nefed versus Alimenta, it's been a roller coaster. Could you please shed some light on the enforcement regime in India?
Thanks, Ishan, and thank you for inviting me on this panel. Ishan, your words from Bhatia onwards, it's been a roller coaster, strike close to home. When I was pursuing my LLM in international arbitration at King's College London in 2011, the Indian Supreme Court ruling in the Bhatia International case was governing the field in India. Now, I remember animated discussions on the ruling and feeling a twitch when people criticized the Indian judiciary for going absolutely against the global tide of advancing arbitration and putting spokes in the wheel while other countries were respecting and enforcing party autonomy, competence of arbitration tribunals, and principles of international comity. From then until now, with Balco, Lal Mahal, Drolia, and several other cases, we have greatly evolved as a jurisdiction that delivers some of the finest interpretations of the Arbitration and Conciliation Act. And as a jurisdiction that offers a rich body of case law and helps in development of law of arbitration as it grapples with its enormous and varied caseload. Now, coming to the enforcement regime in India, I believe we can have an all-day conference on the subject, but I'll break it down for the benefit of our attendees. The enforcement regime in India is twofold. It depends on the seat of the arbitration where the award is made. Now, enforcement of domestic awards, that is, awards emanating from India-seated arbitrations, are governed by Part 1 of the Arbitration and Conciliation Act in India. Enforcement of foreign awards, that is, awards emanating from foreign-seated arbitrations, are governed by Part 2 of the Act. Now, for domestic awards, once an award is received, the award debtor has 3 months to challenge the award. On expiry of the 3-month period, the award holder can apply for enforcement of the award. Now, if during this 3-month period there is a challenge to the award, this challenge alone will not render the award unenforceable, like it was the position before the 2015 amendment. The court would need to additionally stay the operation of the award on a separate application filed along with the challenge petition for the award to be unenforceable during the operation of the stay. Now, the award is enforceable in India as if it were a decree of the Indian court. Hence, awards are executed in accordance with provisions for execution of decrees under the Indian Code of Civil Procedure. Under Indian law, the limitation period for execution of decrees and hence domestic awards that are deemed as decrees of Indian court is 12 years from the date when the decree or award becomes enforceable. Additionally, parties would need to ensure that the domestic award is stamped. If the award affects immovable property, it needs to be registered. One would also need to assess other factors such as the nature of the arbitration, whether it is domestic or international commercial arbitration, nature of the award, whether it is a money award or otherwise, and the value of the award in order to arrive at the jurisdiction of the court where the execution petition can be filed. Now, these were some of the very broad points that one needs to be aware of while having a domestic award or an India-seated award in their favor or against them. Now, the regime for enforcement of foreign awards in India is different. First, upon receipt of the award, a party would need to ascertain if the award has emanated from a seat or a country that is party to the New York Convention, and whether the party or whether the country is notified in India as a reciprocating territory for purposes of recognition and enforcement of foreign awards under Article 10 of the New York Convention. Now, if yes, the foreign award would be enforceable in India under Part 2 of the Arbitration and Conciliation Act. Now, second, while applying for enforcement of the foreign award in the Indian court under Section 47 of the Arbitration and Conciliation Act, the award holder will need to produce before the court the original award or a duly authenticated copy, the original arbitration agreement or a certified copy, and evidence necessary to prove that the award is a foreign award. Now, this is a key requirement while filing an application for enforcement before Indian courts. Third, at this stage, the award holder may face objections to enforcement of the foreign award under Section 48 of the Arbitration Act. 3 points to remember here. The grounds under Section 48 of the Arbitration and Conciliation Act in India are the same as those under Article 5 of the New York Convention. However, additionally, there is an explanation as to what would constitute a violation of public policy under the Indian Arbitration Act. Two, the Indian Supreme Court has held that these grounds are exhaustive grounds. And three, they have also recognized that the power to refuse enforcement is discretionary. So court has discretion in certain circumstances to allow enforcement of a foreign award, even if grounds of refusal are made out. Now, a foreign award, as I said, is different from a domestic award. It is not a decree by itself, which is executable as such under the Arbitration Act. It is only after the stages of Section 47 where I laid out the requirements and Section 48, which deals with objections to the award. When these stages are completed, the award becomes enforceable as a deemed decree as provided under Section 49 of the Arbitration Act. So what one needs to remember is the trio, is these three provisions under Part 2 of the Arbitration and Conciliation Act, Section 47, 48, and only then 49, where the award becomes enforceable. Additionally, very important to note, the award holder will need to be mindful of limitation period for enforcement of foreign award. As per the judgment of the Indian Supreme Court in the case of Vedanta in September 2020, which is recent, a foreign award can be enforced within a period of 3 years from when the right to apply for enforcement accrues. And now that is broadly and very broadly the enforcement regime for domestic and foreign awards in India, Ishan.
Thank you so much. That was quite a 101 on how enforcement happens in India. But I'm just gonna narrow it down to one perspective and one aspect that's going to be on public policy. Now, public policy, I'll just come to a recent judgment that we all read, the Vijay Karya one, which eventually, affirmed the dicta in Cruz City versus Mauritius from the Delhi High Court, where the court says the expression fundamental policy of law must be interpreted in that perspective and must mean only the fundamental and substratal legislative policy and not a provision of any enactment. Now, this is something which perhaps provides a much needed clarity after a lot many years. Not that it wasn't there for the last few years because the High Court said so, but then, getting the affirmation from the Supreme Court perhaps can be said to be a game changer now. So can you please share your thoughts on that?
Since you confined yourself to Vijay Karya, I must mention that I will refrain from commenting on my views on Vijay Karya because, well, Nishit Desai Associates represented Vijay Karya in the matter. But let me move on to the broad point on public policy and why it is a problem. Now, we are all aware of this famous sentence by Justice Barrow in 1824 that public policy is an unruly horse and that public policy is never argued at all but when other points fail. The difficulty with public policy is that it is an open and variable doctrine and very specific to the country where enforcement is sought. However, under Indian arbitration law, public policy is not just those two words left to imagination or interpretation. India is one of the very few jurisdictions to statutorily define the elements of public policy through the Arbitration and Conciliation Act. Now, in Indian arbitration law, violation of public policy is a ground both for setting aside a domestic award under Section 34 of the Act and resisting enforcement of a foreign award under Section 48. Now, although the concept of public policy is the same in nature or appears to be same in nature in these two spheres of law, internationally in some jurisdictions like UK and France, courts have made a distinction between international public policy applicable to considering foreign awards versus domestic public policy applicable to domestic awards. Now, in India, way back in 1994, in the case of Renu Sagar Power, the Supreme Court recognized that there is no workable definition of international public policy. But it did recognize that the expression public policy under the then applicable Foreign Awards Act must be construed as applied in private international law. Now, accordingly, the court held that the award would be contrary to public policy if it is contrary to fundamental policy of Indian law, interests of India, justice or morality. Now, this was public policy in the context of enforcement of foreign awards, narrowly applied, postulating specific elements, and not entailing a review of merits of the foreign award. Now, in ONGC versus SAW Pipes, the Supreme Court introduced the concept of patent illegality as a ground for setting aside domestic awards under the head of public policy, under Section 34 of the Act. Now, patent illegality is broad. It does involve a review of merits of the underlying dispute. What happened thereafter is that in the case of Fulchand exports, the Supreme Court extended this domestic concept of patent illegality to one that was the ground for resisting enforcement of foreign awards. Now, that was undesirable. After several cases such as Sri Lal Mahal, Western Gecko, Associate Builders, and the 246th Law Commission report, we finally had the Arbitration and Conciliation Amendment Act of 2015, where it was clarified both under Section 34 and Section 48, which is for domestic and foreign awards, that an award is in conflict with the public policy of India only if, and that is only if, one, the making of the award was induced or affected by fraud or corruption, or it is in contravention with the fundamental policy of Indian law, or it is in conflict with the basic notions of justice and morality. It was also helpfully clarified that the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Now, two additional things to remember here with respect to public policy for challenge to domestic awards under Section 34 and execution of domestic awards under Section 36 are firstly, as per the amendment of 2015, the ground of patent illegality will apply to challenge domestic awards other than international commercial arbitration awards. Although courts will not engage in reappreciation of evidence, even when they are considering a ground of patent illegality. So that's one forward step for international commercial arbitration awards and foreign awards, certainly, that the ground of patent illegality will not apply to these awards. The second thing to note is that as per the latest ordinance of 2020, a court can stay the execution of award under Section 36 unconditionally, pending disposal of challenge to the award under Section 34, if it is satisfied that a prima facie case is made out that the arbitration agreement, which is the basis of the award, or the making of the award was induced or affected by fraud or corruption. Now, this latest ordinance could be a cause of concern because it could unconditionally stay the award or the operation of the award as soon as there is an allegation or that says that the arbitration agreement or contract, which is the basis of this award, was induced by fraud or corruption. So we need to see how this goes, but this is one downside of public policy that has been introduced by the latest ordinance. So you see, India is one of the few jurisdictions to statutorily define or identify elements of public policy through the Arbitration and Conciliation Act. And through case law, Indian courts have given sufficient content to these grounds. One of the cases being Vijay Karya. There are various other cases where fundamental policy of Indian law has been, further given content to. It includes breach of natural justice, a violation that is much more than merely statutory violation. So my take on public policy in India is that it is important to exercise restraint in examining the correctness of a foreign award or a domestic award tendered in an international commercial arbitration, as opposed to a purely domestic award. And I do often rely on this quote by the court in Cruz City matter, where the court said that a policy to enforce foreign awards itself forms a part of the public policy of India. And courts should strive to find the right balance between the policy of enforcing foreign awards and considering the grounds for resisting enforcement of foreign awards. That is my take, Ishan, on public policy in Indian arbitration law.
Well, very well summarized. And the ordinance could just again be said to be another example of perhaps one step forward, two steps backward. But let's see how that pans out. We still have the courts to help us and guide us through. So thank you so much. Now, before we move to our next speaker, I'm just going to launch a poll for our attendees to participate in and contribute to. And simultaneously, of course, I'm going to move to the next speaker. Please feel free to respond to the poll question, which should be on your screen now. Now, moving on, I invite Mr. Ratan K. Singh. Mr. Ratan Singh, as we all know, is an expert in construction law in India. And as he shared, very highly qualified and uniquely qualified with niche expertise. So Ratan sir, what has happened over the last few years, especially during the pandemic? Could you just briefly give a broad overview of construction arbitration in India and what the future looks like before we narrow down to a very important question that I will share right after you discuss? Thank you.
Good evening, good afternoon, good morning. I must thank the organizers for having me in this panel. Before I take you through the recent past, from the perspective of construction law and construction arbitration, may I take you to 6000 BC, that is the Bronze Age era, when first construction happened. That was building technology utilized clay, mud bricks, and timber. And thereafter, you had the development of fire bricks in 3000 BC, and it went on with the use of steel in around 1800 BC. And when it comes to construction law was first written 1750 BC when Hammurabi Code was written. Obviously, it was an eye-to-eye era. So one of the provisions was that if the contractor has made a construction, it has collapsed, an employer has died, owner has died, contractor will be hanged. If employer's son has died because of the collapse and defect, contractor's son will be hanged. But there was a law. Thereafter, in various jurisdictions, we have seen multiple statutes which covers construction industry as a whole, construction law. However, what we have seen in India is that we haven't had construction law legislations. In fact, I'll tell you in very brief, 2 years back, I was just speaking in Singapore in a construction law event conference. And I was posed 3 questions. Do you teach construction law in your law colleges and engineering colleges? Do you have construction law legislations like security of payment legislations, like you have Housing Grants Act in UK, you have security of payment, SIPA in Malaysia, you have similar legislation in Singapore, in New Zealand. And third question was whether you have got specialized courts like technology and construction court you have in the UK and some other jurisdictions. And ladies and gentlemen, answer to all the 3 questions was no. We do not have even security of payment legislations, which generally takes care of flow of funds for the contractors and other related issues which ensures that project is completed on time and contractor is paid on time. So far as construction arbitration is concerned, in fact, one US federal court judge in Paul Hardman versus ARC Power and Light had said, construction contracts are separate breed of animal. Sometimes people assume that construction law is nothing but advanced version of law of contract, but that's not the case. It has got its own peculiarities. It has got its own very developed jurisprudence, which I need not touch upon because we have to go to construction arbitration. So far as construction arbitration is concerned, 2019 report of ICC says that their 40% arbitrations were construction and engineering arbitrations. In India, situation is almost the same, rather more percentage of arbitrations which we see here, and particularly the bigger arbitrations are construction arbitrations. So what are the peculiarities of construction arbitration and where are we in India so far as construction arbitration is concerned? I must say in the very beginning, in absence of construction law courses in law college and engineering colleges, we do not have very trained construction arbitrators and construction lawyers. Construction arbitrators and construction lawyers which we have are essentially self-trained construction arbitrators and construction lawyers, which is largely the case in other jurisdictions as well. There are not many jurisdictions where construction law is taught. So question today in India is how to develop and how to create awareness amongst the arbitrators and all stakeholders about the speciality of construction law and construction arbitration. Construction arbitration has got its own peculiarity also, in a sense that it deals with long-term contracts. The constructions are generally long-term contracts. These are fact-heavy arbitrations. These are issue-heavy arbitration. I would say that one construction arbitration may be equivalent to 10 or 20 other commercial arbitrations or non-construction arbitration. It deals with voluminous pages of and voluminous documents and evidences. And most important aspect which we are concerned with today is involvement of multiple parties. You have employer, you have main contractor or general contractor as they are called in some jurisdictions. You have subcontractors, you have subcontractors, you have vendors, and you have lenders, you have insurers, you have architects, you have designers. So there are multiple parties, and therefore you have multiple contracts for one project. And that is one aspect which creates problem for construction arbitration. In fact, what happens in India particularly is whenever you have subcontracting in India generally happens in two ways. One is that the main contractor executes a subcontract agreement with the subcontractor and passes on entire rights and liabilities, basically passes on the risk, passes on all the benefits to the subcontractor. Entire work is subcontracted to the subcontractor, and the main contractor will get some percentage of the contract value under the main contract. So this is one form of subcontracting in India. Another form of subcontracting which you see is where main contractor employs various subcontractors. Now, whether you are talking about or thinking about one subcontractor to whom main contractor has awarded the work, who may further subcontract the work, or the another form where one main contractor awards the work to various subcontractors. One thing is in common, and that is if delay occurs at the end of the subcontractor, it may delay the contract execution of the contract under the main contract. Now, most of the disputes between the contractor and the main contractor and employer and main contractor and the subcontractor are common. Then question would be, how does Indian courts have looked at it? In India, so far as this first form of subcontracting is concerned, which is generally called back-to-back, there is one judgment which, in fact, I had occasion to argue in Delhi High Court. That is Telecommunication Consultants India Limited versus NGBPS. There I had referred to laws of various jurisdictions, and essentially one judgment of Hong Kong court in Timley. And I said that was a case where entire work was subcontracted to the subcontractor. But when dispute arose between the subcontractor and the contractor, the arbitrator said, I'm not concerned with what all had happened or what all has happened between the main contractor and the employer. Whereas this contract was a back-to-back contract. It was not only back-to-back with regard to the terms of the contract, but it was back-to-back also with regard to payment. So if there was deduction of payments, or suppose there was imposition of liquidated damages, it had to be passed on to the subcontractor. But the arbitrator had refused to recognize this. which was corrected by Delhi High Court, Justice Naveen Chawla's judgment. So this is one judgment which deals with in some detail, I would not say in greater detail, but in some detail about this back-to-back situation. Otherwise, we do not really have much of law to touch upon this particular aspect of subcontracting. Now, difficulty is all these contracts between main employer and the contractor and employer and the main contractor and main contractor and subcontractor are separate contracts. So therefore, there is no privity of contract between the subcontractor and the employer. And once that is the case, then question comes, which you typically face in commercial arbitration as well, whether non-signatories. So you can have two situations. One situation, maybe it is a case of multi-party arbitration. One can look at a scope or possibility of multi-party arbitration, or another way could be to look at as multi-contract arbitration. But I must say this, unlike in commercial arbitrations, these concepts or the theories which have evolved generally for commercial arbitration, of which gives you exception for impleading the non-signatories or recognizing the non-signatories in arbitration, it has not worked in construction arbitration. Concepts like agency, there is no question of agency in construction dispute. Subcontractor is not the agent, or main contractor is not the agent of the subcontractor. Similarly, alter ego or group of companies doctrine or the promissory, the estoppel, all of this doesn't work in construction arbitration because of the peculiarity of the position of the parties. Second important aspect is that some forms, standard forms like FIDIC has got FIDIC 2011 forms on subcontracting. In fact, I had occasion to speak for FIDIC in an international conference where I had spoken about subcontracting forms of FIDIC of 2011. So like FIDIC, like ICE, like JCT have really given way forward for joinder of parties in a construction arbitration, but it has all have their own challenges. Unless you have drafted it very well, unless it has been agreed by all the concerned, again, even joinder cannot happen or parallel proceedings cannot happen. End of the day, issue is whether parties have, all the concerned parties concerned have consented to have one arbitration or parallel arbitration or to have a common arbitrator. Difficulty is that the employer is always reluctant whenever the employer has appointed a main contractor. Employer will always be reluctant to agree to any arbitration where subcontractors or multiple subcontractors will be party. They want to have one arbitration. They have fixed all the liabilities on the main contractor. So they are always reluctant. So therefore, there is absence of the consent or the part of the employer. Now, various forms are talking about this, but again, question is, there are concepts like name borrowing, which works for arbitration and for adjudication in UK. There are various judgments to that effect. But question is, these all concepts are having difficulties and challenges. The typical concepts, which are exception to the principle that non-party cannot be made a party in the arbitration, those principles have not worked for this. Now, therefore, so far as India is concerned, in fact, I am working on a project where I have been asked to advise a big organization where they award the work to subcontractors and they face two arbitrations. And some may ask, what is the difficulty with two arbitration? You can have two arbitration. but if facts are similar, based on the facts input provided by the subcontractor, you can have similar rejects. Ladies and gentlemen, this is a misnomer. I'll just talk about two surveys. One survey of 2009 of UK and another survey of US, where in UK in 2009 survey, same set of facts were given to 5 seasoned construction arbitrators, and all of them came out with awards which were different from each other on the apportionment of delay as well as on quantum of damages. In UK, in US, it was a very big research where approximately 482 respondents had responded to this. Again, there it was uncontested facts, not very complex construction dispute was given to all the respondents, and all of them came out with different awards, again on the apportionment of delay and as well as the quantum of damages. So therefore, way forward is that parties should, if best idea is to have umbrella agreement where everybody falls under that same umbrella, no issues with that. But if that is not happening, at least the main contractor can have properly drafted contract with the subcontractor, where subcontractor can be made agreeable to the related disputes which main contractor may raise on behalf of the subcontractor and raise before the. In fact, I had won a case where I was representing a Swedish multinational company against a Russian power gent, where I was representing the subcontractor, and the Russian was the principal employer, sorry, the main contractor. And when we raised our claim against the Russian company, they said, we do not agree with your claim. However, so we are denying and disputing your claims. However, we have raised your claims upon the principal employer. Therefore, you should wait for that arbitration. And this is what we have raised before the principal employer. And they, in fact, narrated all the facts, narrated all my claims the way they had raised before the principal employer. Now, I succeeded in getting on the jurisdictional aspect, and thereafter, I argued that it is a case which can be won on the basis of estoppel by pleading. Once my main contractor has accepted my claim by way of a pleading in another proceeding, therefore they cannot refuse to admit my claim in this proceeding. And once they were encountered with this, they settled with us and we got what we wanted. So these are some of my thoughts on subcontracting, because I wanted to cover subcontracting, which is slightly tricky an issue, Ishan.
Thank you, sir. Thank you. In fact, I was going to ask you this question only. And I think we might face some hurdles when we talk about the latest judgment and with Rolia, because they're also, one of the grounds for non-arbitrability is when the cause of action and subject matter of the dispute affects third-party rights. So, there seems a possibility that there might be some inroads which might create certain issues. And of course, as you said, jurisprudence is evolving in this front. In fact, I can mention that it was only in 2020 that the United States Supreme Court also decided on this issue in the case of GE versus Outokumpu. And I was fortunately part of a team that contributed to research in an amicus brief. And there we, in fact, relied on judgments by the Indian Supreme Court as well, talking about the group companies doctrine. And our submission also was in favor of this motion, and it was decided also accordingly. But yes, this is something which of course, over a period of time, we're going to test waters and see how the applicability of different doctrines and judgments pans out in a more practical sense and scenario. But yes, as you shared, perhaps while drafting of agreements, these things can be taken note of and taken care of. It's going to make things more easier for both the employer and the contractors. So moving on, I now invite Shashank. Shashank, you have been a part of many institutions across India. I know you're part of the Delhi International Arbitration Center. You're also part of the Nani Palkiwala Arbitration Center in Mumbai, and you've also been working closely on a lot of things concerning the development of institutional arbitration in India. So, if I may ask, what are the challenges facing institutional arbitration in India?
So, Ishan, I think it is a question that you would recall is being asked for almost 2 decades in India. Very similar answers have been coming. 10, 12 years ago, when LCIA was setting up LCIA India office and was trying to come up with a parallel institution with more customized rules for India, you would recall, both Neeti and Ajay went around the country promoting institutional arbitration, talking about the advantages of institutional arbitration, etc. Back then, I think the difficulty for institutional arbitration was that, barring people who were already aware of the advantages and were comfortable with it, everybody else wanted more predictability, more control over the proceedings, which was possible through the ad hoc mechanism. And something all of us in India know, that unilateral appointment of arbitrator was a thing which dominated the public sector undertaking industry. I mean, as far as all the big government entities were concerned, they were able to appoint the sole arbitrator unilaterally. And when you can do that, you don't need an institution. You literally have, the maximum say in the entire procedure. Now, Supreme Court's judicial pronouncement in Perkins, and subsequently clarification by various other pronouncements by Delhi High Court, Bombay High Court, I think now it has become impossible for anyone to appoint an arbitrator unilaterally. And therefore, you will see that there is a shift from, as far as these PSUs are concerned, from the ad hoc arbitration to institutional arbitration, because now they need credible arbitrators. Also, the repeat arbitrator procedure, that was, a term that I hate to share, but some people were called pocket arbitrators 5 years ago because they were appointed time and again by the same firm or by the same entity. Now, with 2015 amendments, that has also become an impossibility. So I think it is now more out of the need, more out of a compulsion, that there is a shift. I would not really be excited about our practitioners shifting from ad hoc to institutional arbitration just because there are many more advantages, but it is now more out of compulsion. Interestingly, during the pandemic, there were a couple of webinars where I was a moderator or a speaker, and we conducted a similar poll like you did just now. And this is not long ago, this is just 8 months ago. And we still had a 50-50 vote for preference of practitioners in India on institutional arbitration or ad hoc arbitration. It was, the house was divided just equally. So yes, I think there has been a change. There has been a conscious effort to move towards institutional arbitration, but I don't think we have really achieved the kind of response that was envisaged 10 years ago. But important things for us to note would be that India is, at least in 2019, was on the #1 list of CIAC users. We topped the numbers from in terms of jurisdictions who was using CIAC as an institution and CIAC institutional rules. And so was ICC. ICC's numbers, in last 5 years, has seen a dramatic jump. So big contracts, international contracts, are seeing institutional clauses being incorporated. But I think the market that we need to tap, or we are talking about, is the huge market of domestic arbitration, which still majorly likes to go with ad hoc mechanism. Now, people have been talking about NDIAC, that is New Delhi International Arbitration Center bill and an act now, and also ACI, Arbitration Council of India, both of which were a result of Shri Krishna Committee and came in 2019. So we need to understand what is NDIAC, what is the objective of NDIAC, because I see there are a lot of confusion and a lot of myths about what NDIAC is supposed to do. I'm not talking about ACI because I don't think that's the question that you have put to me. So New Delhi International Arbitration Center is a replacement, or I could say a modification of ICADR, which was 30 years ago envisaged as the most premium Indian institution, but it miserably failed due to many factors, and I don't think we need to go in that today. But Government of India decided that they want to, reignite this institutional arbitration theme in India, and they wanted to set up something which should be top class, world class in terms of its infrastructure, in terms of its rules, in terms of people who would endorse it and who would man it. So that's why we now have NDIAC. Now let's see what is NDIAC doing. I mean, it's not been made functional, but even if you look at the act itself, NDIAC is one of the institutions which would perform the function of appointing arbitrators. So, as you know, in 2019 amendments, which are yet to be notified with respect to appointment of arbitrators, now the High Court will have to delegate this power to an institution that is in its jurisdiction. And Supreme Court will also, for any international arbitration, delegate this appointment power to an institution such as NDIAC. So we are not looking at making an ad hoc arbitration into an institutional arbitration. NDIAC is getting power to appoint arbitrators, which is to say in section 11, instead of Supreme Court or High Court as the case may be, is going to ask NDIAC to make an appointment within 30 days as the act envisages, and that's it. So for us to perceive that just because now there is a New Delhi International Arbitration Center, and just because now the power to appoint an arbitrator is to be delegated to an institution, will my ad hoc arbitration automatically become institutional arbitration? I don't think so. I think that would be against party autonomy. So this huge talk about NDIAC, ACI, and Schedule 8, which now has been repealed, where we were talking about how foreign arbitrators cannot be made arbitrators in India seated arbitration, how former judges do not find a place in Schedule 8, and I'll come to Schedule 8 in a minute. So coming back to NDIAC or ACI, it really has very limited role in terms of making India a hub for institutional arbitration so far, because NDIAC will have to make a name for itself. Just by creating an institution which is supported by Government of India or endorsed by judiciary is not enough. We will have to see how it functions, what are the rules, what sort of arbitrators it will impanel. And of course, India independently has to become a formidable seat. So Government of India, as you said, sometimes we see in amendments is one step forward, two steps backward. But judicial pronouncement have been very heartening, have been very positive, have been setting the tone right. So I feel that once India becomes a formidable seat, the Indian institution will also flourish, whether it is MCIA in Mumbai, whether it is DIAC in Delhi, Nani Palkiwala in Chennai, or NDIAC again in Delhi. So now very quick Schedule 8, because again it was a huge cause of concern, though it has been repealed. I must say, Justice Indu Malhotra, who was supposed to be on panel with us, couldn't join for some reasons. She has clarified in number of webinars, and Honorable Law Minister Ravi Shankar Prasad in an address clarified that this does not apply to foreign arbitrators. And it already defines, it already has a clause where any advocate who has been an advocate for over 10 years could be empaneled. So all the judges were already covered in that. And therefore, I think there were more confusions created by people who couldn't really follow what was happening in the parliament and what was really the motive behind bringing Schedule 8. Of course, it was not as clear as it should have been, but it wasn't really a huge cause of concern. Now we see that it has already gone back. What was the impact of repealing Schedule 8? we will come to know in due course.
Thank
So
you.
that's it from me on institutional arbitration for now, unless you have a follow-up
In fact,
question.
yeah, my follow-up question was to be about the Arbitration Council of India, the ACI, and there was this huge uproar, and you've covered that part that NDIAC and ACI, because of lack of understanding and perhaps some sense of ambiguity that it left, that it created waves of concerns around the international arbitration community as to what the future will be like, or again, a fundamental concern remains: you have to do dispute resolution or business in a regime, or associated with a regime where party autonomy is still respected, it's not jeopardized. So I believe those are some of the concerns that remain alive. But of course, as you shared, that there are clarifications that have been issued, there's a better sense of interpretation that has come
Ishan,
to
can I
it.
quickly make a comment about ACI, because this is again
Please.
to deal with a lot of confusion in the, at least in the international arbitration fraternity. So what is ACI's function at the moment? ACI is supposed to accredit institutions. What are those accredited institutions? As we discussed, NDIC will be one of them, and those accredited institutions are getting the power to appoint an arbitrator in an ad hoc arbitration. So instead of going to court, you are going to go to an institution which has been accredited by ACI for appointment of arbitrator, which to me looks like a free service. So I don't really know which international institution is really interested in providing this free service, because as I said, this is not converting your ad hoc arbitration into institutional arbitration. This is not sending parties to ICC or CIAC, even if they are accredited with ACI. And again, Schedule A has been repealed. Maybe some other schedule would come in place of Schedule 8. It talks about empanelment of arbitrators. Now, these are arbitrators who would be empaneled with these accredited institutions. So we are really looking at ad hoc arbitrations where an appointment of arbitrator will be done by an institution, which to my mind should not worry any international institution or any international arbitrator at all. So, if you just put ACI and NDIC together and just look at the sections, most of the concerns would be answered just by plain reading of these two legislations. It really does not impact what's going on and, the freedom of international institutions, because some people said that, oh, India is going the Russian way, where institutions would be regulated, etc. Please, I am not the spokesperson for the government. I'm only relying on what the government has been saying, casting their word on it, that it from the word of it, it doesn't appear to be a regulator at all. It really has very minimal functions. But something that I forgot to cover was in NDIAC, there is a part of which talks about Arbitration Academy, wherein they want to set up an arbitration academy to foster education on arbitration. Something that we really don't do in India, which CIArb has been doing, is training people in award writing. I think that's a fundamental thing, even for a former judge, when he transforms from his, from being a former judge to an arbitrator, to understand what are the components of writing an award and how should he write an award. We see, we spend a lot of time and money on doing this arbitration, and it is set aside just because the arbitrator doesn't have the basic skill set to write a enforceable award. So NDIAC is going to, set up an arbitration academy which will perform the function of fostering education. Maybe CIArb should look at collaborating, and maybe arbitration, NDIAC should look at collaborating with CIArb, because one of its objectives is to do everything through collaboration. So it's not going to be standing in isolation. So let's see.
Yeah.
Thanks.
And in fact, thank you so much. In fact, through the things that you mentioned, you also paved way for our next segment. And everyone in the audience, we are now walking into the last 12 to 14 minutes of this session before we move to the next session on investment arbitration. Shashank, you mentioned things like pocket arbitrators. You mentioned, training in award writing. You mentioned, the need to train people in arbitration. And I think, and of course, we discussed the 8th schedule. That also opens the door to another series and set of questions that's about diversity in terms of age, having younger arbitrators, and diversity generally and broadly. And India being, the largest democracy, it's also important for India to pave the way in that aspect, on that front, and also, to stand out as an emerging leader. So to talk about diversity and opportunities for younger arbitrators, I would first invite Dana McGrath, and then we'll follow on that discussion. And what Google will tell you, but Dana hasn't, is that Dana has also been training WIS-Mooties. WIS-Moot is one of the most, it's the biggest international commercial arbitration moot, and Dana is also an adjunct professor at Brooklyn Law College. And she has been training a lot of Mooties, a lot of now known international arbitration leaders. So Dana, over to you, please.
Thank you, Sean, and hello again to everyone. I'll take the last few minutes of our program today to tell you a little bit about Arbitral Women and also about the WIS-Moot and the opportunities for young people to get involved in international arbitration. So I am the current president of Arbitral Women. The organization was founded back in 1993. It was very small. There were very few people who were active in promoting women in arbitration at that time. It's now grown substantially and has for more than 25 years been promoting women in diversity generally across the globe. And we have members from more than 40 countries. So we've gone from a small group in Paris 25 plus years ago to a global organization. And we've been able to do that because the people who have chosen to join Arbitral Women have been very proactive and engaged in supporting diversity generally and seeking ways to support each other and get involved in the international arbitration community. So I can tell you a few things about what Arbitral Women does, and I'll offer some links so that you can actually learn more about it yourself, because I recognize that time is short. But one of the things that Arbitral Women does is we organize events or co-organize or support events, such as today's event, that advance our mission to promote women and diversity. And an important component of that is awareness of the resources that are out there for women and diverse members of the arbitration community. So today I'm speaking to you as president of Arbitral Women, but I, as many in the international arbitration community, wear multiple hats. So I'm part of Arbitral Women. I'm also part of the ERA Pledge, which I believe will be discussed later this week during the India tour. And I am also part of REAL, the Racial Equality for Arbitration Lawyers. That's another group that was recently launched to support diversity in international arbitration. And I think all of them are aimed at giving access to those who are less visible, less prominent in the field, an opportunity to learn about the field, be known in the field, and have speaking opportunities. And ultimately, if they seek arbitration appointment as arbitrators, to be able to do that. If they want to be lead counsel, basically provide a platform for them to build their career or to facilitate them building their career. So how do we do that? At Arbitral Women, some of the things that we do is we promote our members' achievements and promotions and their activities in the international arbitration space, particularly with respect to diversity, but really any of their achievements. And so if you are a member of Arbitral Women, we tend to reach out to you when we read about something or we learn about something, thanks to Google. If somebody's achievement, we reach out and we say, can we please share this? Because if we share your news with a broader world, they will know more about you and they will be more likely to hire you as arbitrator, mediator, counsel, whatever. And so that's one of the things that we try to do to promote women. We also have a mentorship program, which is a reciprocal mentorship program. So I've been a mentor and a mentee over the years. I'm more in the role of mentor now, but I feel every time I'm a mentor, there are aspects of it in which I feel I'm the learning mentee. There's a lot to be gained from that. It's a one-year program, but it really sets the stage for a relationship, that goes long beyond the 1 year of the formal mentorship. And I think that that's a really useful thing for people who are trying to start out in the field of arbitration, is to find mentors. Sometimes they're called sponsors. It can be informal or it can be formal. We do it formally through Arbitral Women, but anyone who you reach out to informally and ask, how did you achieve, success in this field? What was your path? What are your suggestions? Everybody's path is different. So when I mentor people, I think about who they are and what connects with their goals and their connections and their region of the world. Many of our mentorship pairings are local, if they choose to be local, or if they specifically would like a mentor who's not local, far away, to sort of diversify their access. We can do it that way too. I recognize the time is short. I think you'll learn a lot on our website, but the bottom line is that Arbitral Women also believes very strongly in something that I think has been echoed through everyone's comments today, and that is in collaboration. So Arbitral Women collaborates with the Pledge, with WWA Latam, that's a women's group in Latin America, with the Chartered Institute, with arbitral institutions, with other organizations, and the collaboration across the globe of these organizations that has really surged during the pandemic and over the past years has allowed many more members of the community to have access to the people who are leaders in the international space and to build their careers. So I would also note that during pandemic, while the world has gone virtual, that has been a benefit, I think, especially to some young people who have more access to the conferences and the events that are happening than they did if they had to fly across the world to attend things. And I hope that this continues after the pandemic ends, that we have a very active virtual conference platform continuing, and I congratulate Ashan on that. I think that is a really incredible resource to people entering the profession, also people who have been in law for 20 years in a different practice that want to now enter international arbitration. Those people are welcomed as well, and the way to learn about arbitration is by attending conferences. So some of the best arbitrators could be people who for 20 years did something other than arbitration. And diverse arbitrators on a panel are make it better. So I encourage you to look at all the resources of events that are happening. A few words on the VIS moot, because I realize time is short. So this is my my prop here. This is the mug that you get when you participate in the VIS moot as either a student or list or a coach or an arbitrator or anything. The VIS moot is actually older, I think, than Arbitral Women, or maybe they're contemporaries. It was founded about 25 plus years ago as well. And it is one of the large,
27 years. Yeah.
So yeah, we have the same birthday. I think we celebrated our 25th together. I think I remember that actually in Vienna, not literally together, but the same year. That again, like Arbitral Women, started out quite small and is now one of the largest, if not the largest, arbitration moots in the world. About 400 teams participate in the Vienna rounds. I think 300 in Hong Kong. Don't hold me to the numbers, but I can tell you that having coached for almost 15 years, a team from the United States, it is an incredible platform for students all over the world and young people who wish to arbitrate all over the world to come together, to meet each other, to network, to learn about arbitration, to learn who are the people who are committed to pursuing a career in this arbitration, in this field. And the moot itself is an extremely challenging and exciting activity. Anyone who has been a mootie and has some arbitration experience, I believe, can apply to be an arbitrator. Obviously, there's some sort of screening mechanism by the organization, but to be an arbitrator at the VIS moot sort of brings you into the circle of meeting a lot of the people who are involved in the VIS moot, and there's a very active VIS moot alumni association. So those who graduate from being a competitor or from being an arbitrator or otherwise involved can stay connected to the VIS moot community, which is an incredible platform to learn about international arbitration. Of my students over the course of 15 years, I would say about half of them pursued a career in international arbitration and are very well known. I could tell you, who they are, but you'll probably find them easily using Google. But half of them choose not to pursue a career in international arbitration, and that is fine as well, because the skills that you get by doing a competition like the Vismoot are skills of a lifetime: oral advocacy, international law knowledge, and the international network of connections and people are a fantastic resource for your career, no matter which direction you decide to pursue it. So, and Arbitral Women is connected to the Moot in that we sponsor teams that are predominantly female teams that do not have the financial resources to participate in the Moot without the financial support of Arbitral Women. And so teams apply to Arbitral Women for funding, and we either fund them or we collaborate with law firms that fund them as well. So we like to support the Moot in that way. Arbitral Women does. I realize time's short, so I'm going to let Ashan direct us going forward.
Thank you so much, Dana. In fact, Vismoot and Vienna was the last time I actually met Shashank. We were eating the Sahar Torte at the cafe. So coming back, just one last question, and to our panelists and speakers from the next session, just allow us 3 more minutes, after which I'll hand over the stage to Shweta. So the 2020 ordinance removed the age schedule, as Shashank mentioned, thereby also lifting the glass ceiling for younger arbitrators under 10 years of qualified experience. While global criticism in international arbitration has long ago coined the term for the problem as pale male stale, the trend in India also remains that older gentlemen remain firmly cemented in the tribunal space. Now, can we expect to shatter that glass ceiling for the youth? I've had the opportunity of discussing this with several leading international arbitrators and jurists, and there has been consensus that opening doors for younger arbitrators paves way for better distribution of work. There are also overburdened arbitrators, which inevitably add to the issue of quality time and resources that can be dedicated to a case. On the other hand, there are also several young arbitration specialists who have also acquired special training in the field and continue to engage in the evolving trends. Not only can such arbitrators provide quality adjudication, it can also result in more economical models. Now, it's not that the pandemic will result in reduced workload. Rather, on the contrary, caseload is only going to increase. Now, one question to all of you speakers. I would request 40 to 45 seconds tops. Do you think, can this window be constructively used to reset those fundamentals? Can that glass ceiling for younger arbitrators be shattered? Kshama, I invite you first, please.
Ishan, I was giving this some thought after you asked me today to deal with this topic. Where is the glass ceiling? At least for the arbitration and conciliation amendments, this ceiling was briefly introduced for younger arbitrators, and then it has now been removed. So we can assume that there might not have been much impact statutorily. And young professionals below 10 years of PQE can indeed be arbitrators. However, the ceiling or the question is not just about age or technical PQE. As young professionals, the question we need to ask ourselves is not whether I have now reached the age or met the PQE required to be an arbitrator. The question is, are we equipped to achieve the best outcome for the parties and adjudicate effectively, expeditiously, and efficiently? At least as a young professional, I would ask myself, why do parties prefer to choose older arbitrators? Well, one, because of their depth of knowledge and the length and breadth of experience, which refines the quality of adjudication. So as a first, are we as young aspiring arbitrators willing to deepen our knowledge and commit to this field? Of course, the answer should be yes. But do we have the experience? Well, no. That's where smaller gradual opportunities can help us build it earlier on in our career. You mentioned very helpfully the advantages of having younger arbitrators. But as I see it, at least arbitral institutions can play a key role in offering opportunities to build experience of young aspiring arbitrators, maybe by creating positions for tribunal secretaries in arbitration proceedings, appointing young professionals, at least in low value, less complex cases, and most importantly, in expedited arbitrations, providing training for these roles. CIArb already does that. So I ask, where is the ceiling? It is open for us. And as far as party choice is concerned, I think, as I said, arbitral institutions can play a great role in leading younger arbitrators or younger professionals to become younger arbitrators and efficient arbitrators. So
Right.
thanks for that question, Nishant.
Thanks. Quickly over to Shashank and then to Ratan sir. Shashank, if you could just share your views in 45 seconds on
Yeah,
that.
I'll keep it really brief. I think it's already happening. As far as court appointments are concerned, Delhi High Court, Bombay High Court in the last few years has been appointing younger arbitrators. When I say young arbitrators, they could be, in the bracket of 7 to 15 years of PQE. And as Shama was mentioning, they are usually appointed for disputes which are not really high stake, because the experience is really something that even with best of education and expertise that you may get through workshops, seminars, or courses, you cannot compete with people who have that sort of experience with them. So as far as younger arbitrators appointment is concerned, that's already happening through court mechanism. And institutions like ICC, CIAC have also, at least in expedited procedures, been appointing young partners, youngish senior counsels time and again. So that's, I think, in last few years, we have seen that happen.
Great, thank you. Ratan sir.
I got my first appointment as arbitrator when I was 4.5 years old in this profession. And I got thereafter, I gradually got a good number of appointments thereafter. But I must say that some experience as party representative or as tribunal secretary is needed. It helps you. It gives you experience, as Shama was rightly pointing out. Younger arbitrator doesn't mean that you have come out of law school and you are really equipped enough to sit as arbitrator. Some time to understand the arbitration is needed. Yes, there is no ceiling, no glass ceiling.
Thank you, Ratan sir. And Dana, you were mentioning about the younger groups. If you could just quickly highlight the young arbitral groups within 30 seconds.
Happy to. So I think many of the arbitral institutions have young groups. I was part of the CPR young group, and the young groups put on programs that train people. They both allow networking, but one of the key aspects of training, I think, to the point of if you can't get the job of being a tribunal secretary or that kind of bird's eye view into how arbitration works, what does an arbitrator do, is to go to events that have mocks. Mock arbitrations are tremendously valuable to illustrate to newcomers to the arbitration field how an arbitration works, how arbitrators do their job. And some of the young groups put on mocks for precisely that purpose, so that you can get a bird's eye view into how it is to be an arbitrator, how it is to be lead counsel when your current role professionally does not necessarily afford you that opportunity. So look for the young groups programs if you want to learn more at a young stage.
I think it's safe to say that the consensus here is that there should be more opportunities, starting with tribunal secretaries. So I think that's something that a lot of arbitrators and the institutions in India should start taking up seriously as a guiding model to nurture and forge a lot of young and qualified and well-trained arbitrators over the next decade. And we're going to see a tremendous difference on that front. So with that, I thank all of our speakers. Thank you so much for your valuable input.